appeal in for the 5th District of the State of Florida is now in session. The Honorable F. Lorraine Wallace, Judge, presiding. All persons have business before this court draw near. Give attention, you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Okay, last case we have on the docket for today is Russell Jean Farrington and Margaret L. Farrington versus Physical Medicine Specialist, Inc., et al. And counsel, I am going to assume that appellant would like Mr. Korn 5 minutes for rebuttal, unless you tell me differently. I can adjust the clock as you want, as you decide.
I was going to ask for 5 minutes, so Your Honor, this is 5.
Okay, sounds great. And just make sure everybody who's in here, if you have any device that'll make some unexpected noise, put it on mute or just turn it off. It's probably the easiest way to handle it. And other than that, I have joining me on the panel to my right and your left, Judge Adrian Soud, and to my left and your right, Judge Paige Kildane, both from Duval County. And with that, Mr. Korn, you may proceed.
Thank you, Your Honor. May it please the Court, I'm Michael Korn of Korn and Zemer, along with Kevin Jacob and Tom Brown. We represent the appellants, Mr. and Mrs. Farrington. This case comes to the Court on 2 summary judgments entered by the trial court. And sometimes we have to keep track of who the parties are. This case is a medical malpractice action. Originally, Mayo Clinic was also involved in the case, so when the court looks at the pleadings, you'll see both Mayo and Brooks parties making various allegations. Mayo settles before the summary judgment issues are joined. So we're here on 2 summary judgments entered by the court. One dealt with what has been referred to in the case as Brooks Hospital. They were a rehabilitation hospital, as the court is probably aware of, in Duval County. The court granted a partial summary judgment as to the hospital, claiming that only nursing care could be appropriately brought to trial because the notices of intent brought under 766 did not encompass medical care. The second judgment was as to the entity which has been referred to as Brooks Medical or Brooks Med. That is a separate physical entity, but as we will explain and as set forth in the papers, it is a certainly related entity for purposes of what is really the central issue in our view of the case, which is, was there an identity of interest between these 2 Brooks boxes, Brooks Hospital and Brooks Medical, which allowed the court to relate back the NOI and any of the other papers, which therefore would allow this case to proceed as to the physicians with respect to Brooks Med and to any of the non-nursing parties as to Brooks Hospital. So when we talk about identity of interest, there are cases, as the court is aware, all over the place on the issue of what constitutes the identity of interest. What is sufficient? We cited the Schwartz case, which is, I think, one of the bell cow cases that deals with what are the indicia between these 2 entities, which would allow a court to determine that for all intents and purposes, we're really talking about an entity that knows precisely what is occurring in this case. The underlying case law tells us that when analyzing this issue and determining whether not only the identity of interest exists, but whether that triggers the relation back, was there prejudice? Is it somehow unfair to the so-called new party? We respectfully submit that it is hardly new. There was certainly no prejudice. The issue in this case was really wound care.
How does the claim of prejudice or the need to consider prejudice relate to the substantive requirements of 766-102?
Well, what it does, Your Honor, is the case was pre-suited twice. The first notice of intent was accompanied by the affidavit of the nursing expert, and then several months later a second NOI was sent with the corroborating affidavit of Dr. Bravo, who was a certified wound care specialist. So to the extent that either Brooks entity, either the Brooks entity which now claims only their nurses were somehow at risk during the litigation, or the Brooks Med, which is now totally out of the litigation, can say they had no idea what this case was about, I think is inaccurate, because in essence, By erroneously removing Brooks Med and the healthcare providers completely from the case, this is not a situation where there was one act of alleged negligence. This was a continuum of negligent care over the stretch of the 19 days that Mr. Farrington was inpatient at Brooks. There were all sorts of medical providers who were involved in Mr. Farrington's care or lack of care. Physicians, nurse extenders, registered nurses, dietitians. These are all laid out, Judge Sowd, in great detail, not only in the Bravo affidavit, but also when the trial judge directed the plaintiffs to further supplement their expert witness disclosures. What is Dr. Bravo, for instance, going to testify to? And he states in the material that was then sent in compliance with that order a significant detail as to what the allegations of negligent care were. So when you ask, well, how does that impact on 766? Again, we come back to the precursor. If there's in fact the identity of interest that I referred to earlier, that Brooks Med and Brooks Hospital for these purposes should be deemed as the same entity. And we believe that the factors, and they're laid out in detail at pages 41 through 43 of my initial brief. And what are they? Same counsel, same carriers, same address, same campus, same registered agents. And it's not just one or another or some kind of, well, it was just kind of coincidental. There's no doubt that all of the Brooks entities that are now trying to hide behind the shell knew exactly what this case was about. It was about a lack of care for Mr. Farrington during that 19 days of inpatient. And the wound care that actually was never delivered, he ends up being discharged back to Mayo in worse shape than he was when he was originally admitted. And that's the gravamen of what the NOIs dealt with. And those were all laid out in detail. The other thing about prejudice, when Brooks denied, at the NOI stage, Brooks denies any claim of negligence on behalf of its providers, they specifically referred to Dr. Tannuzzi, who was the managing physician who was supposed to be overseeing the care that Mr. Farrington was receiving. So it's a little bit hard to understand how Brooks can then come in at 2 years later and say, well, this is a new party, new claims. We had no idea about this. They knew all along that the issue was wound care. And so we would submit that there was no surprise, there was no harm, and the trial court should have, even under the new federal standard, even under the Celotex trilogy and all the cases that now we all cite in our briefs about how the courts are to examine and evaluate summary judgments, even under the federal standard. There was certainly a disputed issue of fact as to the linkage between Brooks Med and Brooks Hospital. One very glaring example of that. When Dr. Tannuzzi is deposed, she's asked, who do you work for? And she says, well, I work for the hospital. Well, Brooks later sends interrogatory and says, well, no, she actually works for Brooks Medical. Well, the appellees try in their brief to say, well, she must have just been confused. Well, no, she wasn't confused. She gave conflicting testimony. That's precisely the point of when you have disputed issues of fact, and that's not just a marginal issue here. That goes to the heart of whether there's in fact the identity of interest between these entities, which allows the relation back, which is, of course, under the case law of this court and all other courts, to be liberally construed, because the goal is not supposed to be to have a game of gotcha.
Well, Mr. Korn, I understand the general rule, the identity of interest, but what about Rule 1.650? How does that come in? Legal relationship. None of the cases cited really talk about the medical malpractice context. So talk to me about the interplay there.
Well, I believe there is and we tried to address that, Your Honor, in the briefs. To the extent I can amplify on that, we did talk about 1.650, specifically B1, and the legal relationship between the parties. And here you have, in essence, you may have two separate groups, two separate registrations, and there was Sunbiz documentation that was introduced at trial. But when they are at the same address with the same registered agent and they are the same parties. They have interlocking directors. They're on the same campus. There's nothing that distinguishes when somebody walks through the facility. There are no name badges that say, hey, I'm here for Brooks Med or I'm here for Brooks Health. Those are all kind of one interrelated whole. And so I would suggest to Your Honor that the legal relationship that sub B1 suggests there has been met in this case, certainly for purposes of determining whether summary judgment ought to have been granted. Because, as I said, there are, if Brooks wants to determine, in fact, whether they're really not, that med really doesn't have anything to do with hospital, well, they can prove that at trial. But there are disputed fact issues right now, certainly sufficient to have prevented the entry of a summary judgment for either of the entities, either as to the physicians, as to the hospital, or any of the entities as to medical.
Okay, and with respect to the physicians, I mean, do you dispute that you were notified pre-suit that they didn't work for hospital, that they worked for the other entity?
I cannot say that with assurance. I know that there were some comments about that, but Your Honor, the point of it is whether that is disclosed or stated or advocated or not, you still can't get around the issue of these two entities that basically work in tandem and feed off of each other with, like I say, same counsel, same carriers, same database that they use when treating patients. In fact, Dr. Tanuzzi was asked at one point about, what do you do? Well, I organize and coordinate all of the care team. What is the care team? Is the care team, this person that's wearing a Brooks Health medical hat on or the Brooks Hospital hat on? It's unclear. And if it's unclear, we would suggest that that is what the disputed issue of fact should be allowed to be brought to trial and to reinstate the case so as to allow them to do just that.
And did you allege below that they had a legal relationship, or it seems like you're sort of conflating the identity of interest and the legal relationship ideas from the two different rules, but did you allege either of those two things with respect to the Brooks Hospital and Brooks medical group?
I believe that it was asserted that was the whole purpose of the amended complaint, Your Honor. And many of the allegations that were contained in the answer brief before this court were really more pleadings issues than they were facts or claims that there were undisputed facts at the summary judgment stage. So to the extent that either of the Brooks defendants attempted to show that, well, we shouldn't be able to have this amended complaint come at us at the last minute, the trial court denied that. And the trial court did at least identify that the identity of interest was the central issue in the case. And in the order that was entered, which denied the motions for summary judgment by Brooks Med and Brooks Health, it said, well, let's have a more robust or more fleshed out evidentiary record on what in fact are the indicia between these two, Brooks Medical and Brooks Health. So the type of things that I think Your Honor is addressing are really more pleadings issues that would go to the motion to dismiss stage. We're past that. The court denied the motion to dismiss, allowed the complaint to proceed on. It was just now to the summary judgment. And although the court was partially right in recognizing that the identity of interest was a central issue that would be dispositive, we submit that the trial court didn't get it right when determining that there was no identity of interest. And ironically, if you read the two orders, there's very little, if any, discussion about whether they be the Schwartz factors or any of the identity of interest. Simply, one of the orders just says nursing care is not medical care. Okay, well, that's, interesting statement. But remember...
That's true, you would concede.
Well, nurses are registered differently than physicians, but in this case, Your Honor, we have a different type of treatment plan. We have wound care, which is, I would argue to be, whether it's practice creep or interdisciplinary, you have a whole host of different professionals with different skill sets that are supposed to be working together in a continuity fashion to serve the patient. So it's not just, the physician, the orthopedic, did something bad to somebody's hip. It's a simple, identifiable, discrete action.
A nursing expert could not provide an affidavit for a notice of intent to initiate litigation to a physician or his office. You concede that?
That would be true. Of course, in the supplemental authority that we brought to the court just last week, a case out of the Fourth seems to be suggesting that what was sort of a kind of hard and fast set of cases that talked about credentialing for purposes of giving an opinion with the 766 notice is somewhat now in flux. But Your Honor is correct, but in this case it's irrelevant because we have Dr. Bravo, certified wound care specialist, who goes into detail, talks about the lack of care at Brooks. And the irony is, as I say, you come back to Your Honor's question from a few minutes ago. Was there harm? Was there prejudice? Well, they knew all about Dr. Tannuzzi. Dr. Tannuzzi is, in fact, referenced expressly, as well as one other physician. When they say, we saw no negligence by Dr. Tannuzzi in the care that was provided as part of the wound care continuum during this 19 days.
And I guess the reason I asked the question earlier was I think trial courts rightly are, in their analysis of issues that may be in front of them, whatever those may be, they have in their quantum of consideration what prejudice inures to the other party by the complained of act or amendment or the like. I guess for purposes of this appeal and this particular case, is a trial court's consideration of prejudice cabined to a meaningful degree by the substantive requirements of 766?
I don't believe it is, because 766 is going to be deemed as satisfied if you have this stepping stone approach. If the identity of interest is established, you then have the relation-backed doctrine, and the case law says that the relation-backed doctrine would include the NOI stage. I see I'm into my rebuttal, so I'll sit down and await my next opportunity. Thank you, Your Honor.
Mr. Pedersen, you may proceed.
Thank you. May it please the court. Brian Peterson on behalf of the appellees of the law firm Childs, Hester & Love. I think it's important to remember that there are two appellees here and two issues. The analysis is not the same. As to the group, one, it was never served with a notice of intent. That's not been disputed below. That is a condition precedent to allow a cause of action to be filed against the group. And we know there's no dispute that that wasn't done in this case. That is a substantive requirement of law. The group has a substantive right to receive that notice. And the plain language of Rule 1.650 confirms that that is the rule that controls whether notice could be imputed from the hospital to the group. We know in this particular instance that there is a robust body of law that discusses what legal relationship means for the purposes of Rule 1.650. That's cited extensively in my brief. I don't know that we need to review each and every one of those cases, but generally we're looking at circumstances where there's vicarious liability of one party for another. Not circumstances like this, where there is a group who has an employee physician with privileges to practice at a hospital. And I think if you read the case law closely, particularly the King case out of the 3rd DCA, it seems that the body of law would suggest, if not, strongly suggest that the relationship of privileges at a hospital is not one of those legal relationships that would permit imputation of notice per the rule. And that's dispositive, again, because that's a condition precedent. And so that summary judgment order should absolutely stand. And there's another reason why it would stand, because the trial court found that the failure to serve the notice on the group was willful. That is a separate grounds that would warrant affirmance in this case, because the case law is clear that a willful failure to comply can also result in dismissal and could be dispositive, and the trial court found that. And the appellants have not suggested that there's any evidence to the contrary, and our record doesn't contain any evidence to the contrary. I want to talk a little bit about Dr. Tannuzzi's testimony, because I think it's important to put that in context here. And that's on page 1604 of the record. So mind you, to be clear, per our record, the answers to interrogatories which confirmed to the appellants that Dr. Tannuzzi was employed by the group and not the hospital, those were served about 2 months before she was deposed. She was deposed in September. The verified answers were served in July, so appellants had that information available to them. And in fact, that may be why they asked her, who is physical medicine specialist? Let me read a little bit of the testimony that my opponent discussed. And it's on page 1604 of the record, and since it's a condensed transcript, it starts at page 8, line 12. the question is, all right, would you please take us through maybe number one, where are you employed now? And her answer is Brooks Rehabilitation Hospital. Physicians with privileges work at the hospital. That does not indicate that there is an employer-employee relationship. Just like I'm here working at the 5th DCA right now, that doesn't mean I'm your employee. That's not enough. And next, the question is, all right, are you actually an employee of Brooks? Doesn't clarify, are you an employee of the hospital? And we know, there's a footnote in my answer brief where I explain that both entities are called Brooks. Their fictitious names include Brooks. And the next question, the very next question is, what is Physical Medicine Specialist, Inc.? And then the witness clarifies, I don't understand the question. And so next, counsel goes on, are you familiar with an entity by the name of Physician Medicine Specialist at 3901 University Boulevard South? And her answer, that's where our clinic is, so I couldn't be certain, but I'm presuming that must be sort of the name they have us under. All right, when you say they, who are you referring to? So you have a witness who's asked an imprecise question, never clarifies what is meant by Brooks. The questioning counsel, which is counsel for the appellants, doesn't ask her to clarify. And and for good reason, because he's already in possession of the answers to interrogatories, which confirm she is employed by Physical Medicine Specialist. Now, appellants go on to talk about a host of other discussions she has throughout the deposition in reference to, quote, Brooks, and seems to suggest that the witness had some obligation to clarify. Mind you, when this deposition was taken, the group was not a defendant in the lawsuit, and the only pled claims were claims for nursing conduct. I've identified those in the brief. I think the record is crystal clear. The allegations are nursing owed a duty of care, nursing violated the standard of care, and here's how they did it. And so we have a witness who, if we interpret that testimony in the light most favorable to the appellants, which we are required to do on summary judgment, we can conclude that the witness is unsure as to the specific identity of the business organization that employed her, but we also at the same time have evidence in the record, verified answers to interrogatories identifying that employer. It certainly was not counsel for hospital's obligation to clarify that. She had already done so 2 months earlier by serving interrogatories. And so the trial court was absolutely correct in entering summary judgment for group. And next, I'd like to talk a little bit about the claims against the hospital, because there's some important points that we need to discuss. So again, it's important to point out the identity of interest exception, which is what appellants argued below. When does it apply? We have a clear body of case law that's actually relied on by appellants that says that case law applies when there has been a mistake and the defendant or the new party has reason to know that the plaintiff has made a mistake and identified the wrong party. The cases go through all sorts of different iterations of factors that might allow a court to reach that determination, but the important point is it doesn't apply unless it's a case of mistaken identity. Our record is crystal clear. This was absolutely not a case of mistaken identity. Counsel for the hospital put appellants on notice repeatedly that this physician, Dr. Tannuzzi, was not an employee of the hospital, and here is her employer. Counsel knew that years before they ever made any effort to assert new claims for physician conduct. Judge Saudi asked a question about physician claims versus nursing claims. Those are separate and distinct. Physician claims require an expert to specialize in the same specialty as the physician. Nursing claims, you can get away with a physician or a nurse, but a nurse would not be competent to give testimony on the standard of care for a physician.
You obviously would advocate that Judge Norton's statement, nursing care is different from physician care, is meaningful to her analysis.
It's quite meaningful, Your Honor. It's the basis for the decision, or at least in part the basis for the decision. Although in context, what she's hearing from the appellants in this situation is argument about a standard that doesn't apply to the facts of their case. Because that lengthy hearing transcript, which I won't go through ad nauseum here with you, it's clear that that's what the arguments were. That's what the briefing was below. It's all argument about the identity of interest exception, which didn't apply to the facts of the case because this wasn't a mistake. The failure to do so had nothing to do with a lack of knowledge or some something in the medical records that made it unclear as to who was the appropriate party. So these are factually distinct claims, and the trial court was absolutely correct in entering summary judgment because they came too late. I want to talk a little bit about one of the cases that may not at first glance seem particularly apropos, but I think when we think about it in determining whether these claims were factually distinct, it is important. That's the Lefebvre versus James case, which is identified in the answer brief. It's 697 Southern 2nd, 918, 920. It's not a medical malpractice case. It's a case about pig feed. And what's interesting in that case is that was a determination where the trial court was correct in making a determination that a shift in theories, even though emanating from the same general factual situation, the same business transaction, did not relate back for the purposes of Rule 1.190. The distinction was, and I'm paraphrasing here, but the question was, does a shift in theory from negligence in creating a pig feed that doesn't have the nutrients necessary to give sustenance to livestock, may the party shift their theory to then allege that there was negligence in delivering the wrong product? And the answer was no. And the distinction is an important one. Was there negligence in the design of the feed on the front end, or was the negligence in delivering the wrong product on the back end? By analogy, that's the same type of situation we have here. For physician claims, was there negligence in coming up with a care plan on the front end and making sure the appropriate steps had been advocated for in the medical record? Or was it the failure of nursing to carry out that plan? Those are factually distinct claims, even though they involve the same general transaction, and that's why the trial court was right in this situation as to the summary judgment for the hospital on these new factually distinct claims, even though they arose from the same general factual situation. A couple of additional points to make. I think there's an argument from the appellants which would suggest that somehow the allegations in their notice of intent or their claims should affect the identity of interest in this case and might allow relation back. I just want to make it clear for the record that argument's been raised and rejected by the 5th DCA in Rayner versus Aircraft Spruce Advantage, 38 Southern 3rd, 817, case from 2010. They explained in the footnote that notice that the plaintiff has sued the wrong entity doesn't depend on a claim. A claim does not establish notice. It's what are the allegations in the complaint. And the allegations in this complaint were crystal clear, at least the initial complaint. This is a nursing case, and that wasn't in dispute. My opponent talked about a recent case that he had identified in a notice of supplemental authority. That was and I want to just be clear that, and seemed to, I thought I heard him suggest that was an indication that the courts were loosening the standard for expert testimony under 766. It's not a 766 case. That was a Fabre case. And the court explained that this is a defensive posture, and the defense doesn't have the same obligations that the plaintiff would in a medical malpractice case, and went on to explain, or the basis for the holding, that the defendant in that case did not need to hire a separate expert in order to support a Fabre defense was because 768.81 did not explicitly require that. That case has no bearing on the facts, and it doesn't stand for the proposition that the 766 standard, specializing in the same specialty, has been relaxed at all. It's not about a plaintiff's burden of proof. It's about a defendant's burden of production to respond to that burden of proof. Unless there are questions, I don't know that there's anything more that I can add that's not already been identified in the papers. The trial court was absolutely right on both of these summary judgments, and both should be affirmed. Thank you, Your Honors.
Okay. Corn, you have about 4.5 minutes.
Thank you, Your Honor. We weren't suggesting that Guzman was a 766 case, but we were suggesting that the idea that what's a qualifying expert, whether it's under Fabre standards or under 766, is at least somewhat in flux. But that's really not what this case is going to stand or fall on. Counsel suggests that the only time you can assert the identity of interest defenses if there's somehow a mistake. I would suggest to the court that's not what the case law says. We specifically looked at the cases. They're found at pages 38 through 40 of our initial brief. And it's not just that somebody said, I thought I was suing ABC Inc. and it was ABC LLC. Under these circumstances, it is really difficult to get a sense of which Brooks hat is which party wearing at that moment in time. Counsel suggests that Dr. Tannuzzi was somehow confused, and they had no obligation, the Brooks parties, had no obligation to clarify Dr. Tannuzzi's confusion. Well, confusion is what is called, I thought, disputed issues of fact. And even under the federal standard, a determination that the head of the caregiving team for wound care, because they didn't have a separate wound care specialist, but Dr. Tannuzzi was it. She was in charge of the care for Mr. Farrington. To say that, well, we're not really sure what she was doing, that we somehow knew that she was really working for the hospital and not for the medical group or vice versa, that is, again, a disputed fact issue. And that's what the court ought not to have taken away when rejecting the identity of interest. Dr. Bravo specifically identified, again, he's board-certified family medicine and a certified wound specialist. His affidavit specifically talked about what happened while Mr. Farrington was inpatient at Brooks. His wounds that he came to them with from Mayo worsened. This is all as a result of a fracture that that Mr. Farrington had suffered while at Mayo, and they had put a brace and some type of what they called the life vest on him. It was apparently, according to Dr. Bravo's review of the records, improperly put on too tight, such that significant necrotically developed wounds occurred. To say that, and kind of addressing what Judge Stout had asked before, this is not a situation where somebody this is a bad leg off case, or I didn't prescribe this medicine and the patient had a bad outcome. Here, the problem was that under the 19 days of care, Mr. Farrington was not cared for properly. And when counsel says, well, it's only a mistake about who was actually providing that care during that continuum, we suggest that's not what the case law provides. He refers to this Lefevre case about the animal feed. I would suggest that I don't believe that has any real bearing on this case. This wasn't a change in theory, and that's why I say if you go back to what Bravo says in his affidavit, and it's found at page 317 of the record. There was no change in the theory. The theory was this man got inadequate, negligent, harmful wound care or lack of wound care. It didn't somehow change, say, oh, and by the way, he also got pneumonia, or oh, by the way, he developed some other condition. This was the same problem that this gentleman had through the entire hospitalization stay at Brooks. So there was no change in theory. There was no somehow surprise to any of the Brooks entities. This was a consistent complaint, and we would suggest that the court should not have allowed the hospital to only have their nurses at risk, and the court should not have allowed Brooks Medical to escape liability in its entirety. We would respectfully submit that the court reverse both of the summary judgment orders, and I appreciate the court's time today.
Thank you for your arguments. Case was well argued, and we stand in recess.
All rise.